In June 2025, a team of automated tools and human reviewers at OpenAI identified a ChatGPT account belonging to a 17-year-old in British Columbia, Canada. The account had been used to describe scenarios involving gun violence. The account was banned. No call was made to police. 8 months later, 8 people were dead. At the time, OpenAI's safety guidelines were governed by the model spec and internal safety red teaming protocols designed to prevent the generation of harmful content. While the account was banned for violating the company's terms of service regarding the promotion of violence, no call was made to the Royal Canadian Mounted Police, RCMP. This decision was made under a then-existing policy that prioritized user privacy and only mandated law enforcement intervention in cases of imminent and specific threats to life, a high legal bar that many Silicon Valley firms have historically struggled to navigate. No provincial or federal laws in Canada specifically required AI companies to report such red flag behavior to authorities, leaving the decision entirely to corporate discretion. 8 months later, 8 people were dead in a tragedy that has since ignited a global debate over the duty to report in the age of generative artificial intelligence. This video will walk through exactly what happened, who made which decisions, and why the question of what AI companies are required to do with what they know is now being asked in courtrooms, legislatures, and government offices on 2 continents. Tumbler Ridge is a mining town in northeastern British Columbia, with a population of approximately 2,400 people, according to the 2021 census. On February 10, 2026, 18-year-old Jessie Van Rootselaar killed her mother, Jennifer Strang, and her 11-year-old half-brother, Emmett Jacobs, at their home. She then drove roughly 1.5 kilometers to Tumbler Ridge Secondary School, a public school serving 191 students from grades 7 to 12. Inside the school, she killed 5 students and 1 teaching assistant before dying of a self-inflicted gunshot wound after RCMP arrived. The death toll of 8 made it the deadliest mass shooting in Canada since the Nova Scotia attacks of 2020, and the deadliest school shooting in the country since the École Polytechnique massacre in 1989. Among the wounded was 12-year-old Maya Gebala, who was shot 3 times, in the head, neck, and cheek, and remains hospitalized with a catastrophic traumatic brain injury. Her mother and sister have filed a civil lawsuit against OpenAI in BC Supreme Court, alleging that ChatGPT served as a trusted collaborator that provided Van Rootselaar with information and guidance in planning the attack. Those allegations have not been proven in court. What is not in dispute is the timeline. In June 2025, OpenAI's automated detection systems and a team of human reviewers flagged Van Rootselaar's account for policy violations related to violent content. The account was suspended. OpenAI's internal threshold for contacting law enforcement required that activity represent a credible and imminent risk of serious physical harm. The company determined that standard had not been met and made no referral to Canadian authorities. Van Rootselaar then created a second account, which OpenAI says it only became aware of after the RCMP publicly identified her name following the February attack. In the weeks after the shooting, OpenAI Vice President of Global Policy Anne O'Leary stated publicly that if the company's current reporting protocols had been in place in June 2025, Van Rootselaar's account would have been referred to law enforcement. That statement is, in effect, an acknowledgement by the company that its previous standard was insufficient by its own revised measure. The public apology from OpenAI CEO Sam Altman came slowly. British Columbia Premier David Eby had stated in March 2026 that Altman had agreed to apologize to the Tumbler Ridge community. The letter, dated April 23, 2026, was shared publicly by Eby on social media and by the local outlet Tumbler Ridge Lines. In it, Altman told the community that he was deeply sorry OpenAI had not alerted law enforcement about the account banned in June, acknowledged the harm and irreversible loss the community had suffered, and reaffirmed commitments he had made in earlier conversations with Mayor Daryl Krakowka and Premier Eby to work with all levels of government going forward. Eby, while acknowledging the apology as necessary, publicly described it as grossly insufficient for the devastation experienced by the families of Tumbler Ridge. Federal AI Minister Evan Solomon separately stated that Altman had agreed to establish a direct point of contact between OpenAI and the RCMP and to add protocols directing users in crisis toward local support services. Tumbler Ridge is not the only case in which ChatGPT's conduct before a mass shooting is under legal scrutiny. In April 2025, Phoenix Ikner, a 20-year-old student, killed 2 people and injured 6 others at Florida State University in Tallahassee. Court filings indicate that Ikner submitted numerous queries to ChatGPT in the period before the attack, including questions about firearm operation, optimal times to find high concentrations of people on campus, and the approximate number of deaths required to generate national media attention. In April 2026, Florida Attorney General James Youthmeyer announced a criminal investigation into OpenAI, issuing subpoenas for the company's internal policies, training materials, and red flag reporting procedures dating back to March 2024. Youthmeyer acknowledged publicly that the investigation was entering legally uncharted territory, with no settled precedent for criminal liability assigned to an AI platform. Ikner has pleaded not guilty. His trial is set to begin in October 2026. Now consider what the divergence in possible outcomes actually looks like. If binding mandatory reporting legislation passes in Canada, in Florida, or at the federal level in either country, AI platforms would be required by statute to notify law enforcement when user activity crosses a defined threshold, with that threshold set by regulators rather than by the companies themselves. Detection, referral, and documentation would carry legal consequence. In that scenario, the question of whether a flagged account in June 2025 meets an internal company standard becomes irrelevant, because the standard is no longer theirs to set. In the alternative path, no binding legislation passes. Companies update their voluntary protocols, as OpenAI has already begun to do. The threshold for what constitutes an imminent threat remains an internal judgment call, subject to revision after each incident, rather than defined in advance by law. The gap between those two futures is not a technical gap, it is a governance gap. OpenAI's own revised protocols, by Ann O'Leary's account, would have produced a different outcome in June 2025. What does not yet exist is a mechanism that requires any company to apply its own best judgment before a tragedy rather than after one. Tumbler Ridge had one secondary school. The investigation into what happened there is, as of April 2026, in its final stages, according to Premier Eby. What comes out of it, in courts, in legislatures, and in the internal policy documents of the companies that build tools used by hundreds of millions of people, is what to watch next.